Good afternoon, everyone, and good morning to all of those joining us from the West Coast, including our panelist, Helen. Welcome to our first webinar of the 2023 Estate Litigation Series, Navigating Estate Disputes. Thank you all for joining us today. Please see the information slide right now that will appear on your screen. My name is Labonté, and I'm an associate at Fasken Litigation and Dispute Resolution Group in Montreal. Within my practice, I handle various civil and commercial litigation cases, more specifically estate litigation. I will be moderating today's discussion. I am joined by my colleagues, Yoni Feingold and Helen. Helen Lowe is a partner and the leader of the Wills, Trusts, Estates, and Charities group in Vancouver. She assists clients with contentious disputes regarding wills, trusts, inheritance, powers of attorneys, and elderly and incapable family members, as well as estate planning for both simple and complex estates with a goal to avoid post-death disputes. Yoni Feingold is a partner in Fasken Litigation and Dispute Resolution Group in Montreal and my mentor. His practice is centered on the resolution of disputes concerning wills, trusts, estates, and general commercial litigation matters. So there's a number of ways in which an estate plan, seemingly valid, may be attacked after death. During this webinar, Yoni and Helen will review those types of attacks and the basic elements of them and explain how these can be resolved. They will focus on three main challenges, being first, claims that a will is invalid for defects of form. Second, claims seeking to invalidate a will based on the testator's lack of capacity, and third, claims seeking to invalidate a will based on the concept of undue influence exerted over the testator by a third party. So Yoni, perhaps the best way to start this webinar is for you to remind us what are the formal requirements under Quebec law for making a will.
Thank you, Marie-Ève. Thank you for the nice introduction, and thanks to everybody for joining us today. So under Quebec law, there are three types of wills that are legally recognized. The first is a holograph will. There's a will before witnesses, and there's the most formal of wills in Quebec, which is prepared by a notary or a notarial will. Each one of these wills has its own particular formal requirements that have to be respected in order to be considered valid, validly prepared and valid under the law. Challenges to a will on the basis of its formal validity is essentially a challenge concerning the manner in which the will itself was prepared. So let's look at these three types of wills and their formal requirements, and we'll understand exactly how those challenges work. So as I said, the first type of will in Quebec, it's the simplest and the most basic form, is what we call a holograph will. A holograph will is written entirely by the hand of the testator and signed by him. There are no other requirements necessary. It doesn't even have to be dated. Handwritten and signed, that's it. While it's not the most ideal form of will and not one that we really ever recommend to our clients or to the public, it's certainly a useful instrument if you find yourself in a pinch, so to speak. So for instance, if you're about to go into emergency surgery and you have your wits about you and you haven't prepared a will, then you can write something down, sign it, and that can be validly considered your will should something unfortunately happen to you and you not wake up from surgery. Many of the challenges that concern holograph wills deal with whether or not the document itself is an expression of the testator's last wishes or is more akin to sort of a list of instructions and guidelines that the individual has prepared for their lawyer or for their notary for the preparation of something more formal. That involves then a evidentiary hearing where people who, parties on one hand who want to probate it, try to make proof that in fact this document represents the last wishes. The next type of will is a will before witnesses, also governed by the Civil Code of Quebec. And those wills, as the name suggests, is prepared by the testator or by a third person and signed in the presence of witnesses. Now, the code specifically states that it can be prepared by a third person, and the courts have recently stated and held that that third person cannot also be a beneficiary under the will. So you can't have son preparing the will for dad and then dad signing it and that being a validly prepared will before witnesses. That issue has been brought up to the Court of Appeal, but the most recent judgment ruled on other issues, dismissing the probate of the will for other reasons. So it may still be a question that comes up in future litigation. The other requirements are that the testator must declare in the presence of the two witnesses that the document he's about to sign is in fact their will, or the document that they just signed happens to be their will, and they need not divulge the contents. The witnesses then sign the will immediately and in the presence of the testator. And that rule also recently changed or was softened as a result of our experiences during the pandemic, when people were not allowed to gather together and witnesses couldn't be in the presence of a testator while they were signing their will. So exceptions have been made to that rule. Finally, if the will is prepared by a third person or by technical means, meaning it was printed on a boilerplate, the parties have to initial every single page, and a legacy made to one of the witnesses is without effect. So that covers will before witnesses, those formalities. When those formalities aren't met, you'll see a challenge. The final form of will is a notarial will. As I mentioned, it's the most formal of the types of will recognized under Quebec law. And they're also deemed to be an authentic act, which means that the notary who prepares and receives the will, so they receive the signature by the testator in front of witness, will issue a certified copy of that will, and that certified copy is considered an authentic and valid will, assuming it is the last will that has been registered or found. No other proof of the document needs to be made. The certified copy is sufficient, unlike the will before witnesses and the holograph will, which need to be probated. The notarial will does not. So those are the three types of wills, Marie-Ève.
And Yoni, in the event that a will does not meet the formal requirements for the type of will that it is it automatically invalid, or is there maybe a way to, is there a remedy available to save such a will?
So yes, under Quebec law, we do have a remedy available to correct a defect of form. It's available really for wills before witnesses or a holograph will. And the two conditions that have to be met are, first, the will has to meet the essential requirements of the will. And second, the court has to be convinced that the document unquestionably and unequivocally contains the last wishes of the deceased. I'm reading directly from the code, Article 714. So there really has to be a demonstration, and it's evidentiary in nature, that this document unquestionably and unequivocally reflects the last wishes of the deceased. In a holograph will, as I said, the essential condition is the signature, without which, forget it, you don't move to the second, you don't make the evidentiary proof. If there's no signature, it's totally fatal. Will before witnesses, the courts have shown themselves to be a little bit more flexible with the requirements. You obviously need a signature. You need to have a witness. Do both witnesses need to sign? No, we've seen cases where only one witness has signed, but the declaration was made in front of the second witness. So even though there's a defect in form of that nature, the court has nevertheless allowed it to, has probated it and remedied that defect. So that's the remedy available here.
Thank you, Yoni. So, Helen, having heard from Yoni about all these on the types of wills that are available under Quebec law and their respective formal requirements, is there anything to add for the common law provinces? And also, does the remedy of rescuing defective will also exist in common law?
Okay, well, thank you. And it was very interesting to hear how Quebec treats wills and formal validity. I'm going to try to do 10 provinces and 2 territories in the same amount of time. So I'm going to be very broad brush about it. So let me say this. The provinces have differed with respect to what is required for a valid will. Almost every province has generally a requirement where the will needs to be signed, where there needs to be 2 witnesses, and the witnesses need to be independent from the benefits that are conferred under the will. Having said that, there have been provinces that have recognized holograph wills for a very long time, like Saskatchewan, and other provinces, such as the one I practice in British Columbia, where there was a requirement for strict adherence to the formal requirements of 2 witnesses in writing, everybody together and witnessing each other's signature until 2014. And I'll discuss that further. But in each of the provinces, they have different types of formal requirements. Certainly, I think that you have to be of age, although if you're going into the army or going into war, you do not. Hopefully that will never happen, that we have to introduce those type of procedures. But most common law provinces had a relatively strict rule to deal with the validity of wills. And that was to protect and ensure that the estate would pass in a way that really reflected the willmaker's intentions, that there wasn't fraud that would be done in the will-making process or the will proof process. And this is all changing. So various provinces, including British Columbia and Ontario, have provisions now with respect to remote execution. And I expect that that's going to ever evolve so that ultimately a computer stored electronic signed DocuSigned will probably be legislatively valid. But right now, where a will does not meet the formal requirements, all of the larger provinces, and that includes Ontario, British Columbia, and Alberta, there are, and the prairie provinces have legislation that allows the court to go and rectify a will. That is, fix something and declare it to be valid, notwithstanding that the technical legislative requirements have not been met. And so the question is, how far can a court go there? And British Columbia probably has been the last province that has allowed for that. And so it's relied on a lot of case law in the other common law provinces that have found various other, what I would call documents, or maybe that word is even too narrow, but other things, other expressions to be valid wills. And the most infamous, which I learned in law school a long time ago, because this case was in the 40s, was that there was a Saskatchewan farmer who was trapped under his tractor. And he went and used a knife that he had in his pocket to scratch out on the tractor fender what he wanted. And the court in Saskatchewan validated that as a will. And there's some, obviously the other cases have been far less dramatic, but what we have seen in the common law provinces is that the courts are relatively open to declaring something to be valid, notwithstanding how much it departs from the formal requirements, such as it might not be signed by the will maker. It may have no witnesses. It may not entirely be all in writing. And now we've got, and I have some current cases where people have videotaped themselves. And the question is the videotape, which is oral, obviously, and visual, but is that a document to be proved as a valid will? So there's a lot of interesting developments that I think will continue to happen as we progress in our technology and the way that people communicate. But I would say that in all of the provinces, when trying to validate something that doesn't meet the formal requirements, the court is looking at, is this a settled testamentary intention? Is what is before me that is being sought to be proved as a valid, enforceable will that would govern the disposition of a person's estate? Is it the final, confirmed, settled, real, definitive wishes of the testator? And if it is, and the court finds that on whatever evidence is presented, then the courts generally will validate an imperfect will or validate certain provisions in this imperfect will that meets the test of definite, settled testamentary intention. So that is the rest of Canada, Maria.
Yes, thank you very much for covering 9 provinces this morning with us. Now that we have covered challenges with respect to the effects of form, let's discuss cases where the validity of a will is contested based on the testator's lack of capacity. So maybe, Yoni, you can talk about how these cases are dealt with in Quebec.
Yes, absolutely. So I'll do my best to cover a single province and the rules that operate here, although I know that they're similar for the rest of Canada. So these types of challenges are quite frequent. We were regularly consulted, even before litigation begins, we're consulted by a family member who is considering taking an action to invalidate a will on the basis of the testator's incapacity at the time that they prepared it. The circumstances tend to be where the will was prepared perhaps on the testator's deathbed, so really shortly before dying, within the hours, days, or weeks before death, or during a period when the testator was receiving treatment, medical treatment for a medical condition, and also often wills that were prepared after an initial diagnosis of Alzheimer's or dementia. And it's important to note that the mere a diagnosis is not sufficient for anyone to conclude that the testator did not have the legal capacity to testate, to express their final wishes with respect to the disposition of their property. To understand, to get to the heart of the challenges, we have to understand what we mean by capacity in Quebec, which I assume is going to be very similar for the rest of Canada. So here in this province, the notion of capacity is the ability to understand what is set out, what is written out in the will, and also to appreciate the legal consequences of the act itself. Capacity is considered and evaluated at the time of the execution of the will. So not the days before, when the person may have been in and out of consciousness in hospital, and not afterwards, where the person may have recovered and then experienced some delirium, but really at the very moment that the will was executed, did the person or not have the capacity? One also has to bear in mind that under the law, there is a presumption of capacity. The Civil Code provides for that. Everyone is presumed to be capable of exercising their rights, which means that if you're challenging a will on the basis that the testator did not have capacity, it's your burden to prove on a preponderance of probabilities, which is the civil law threshold, that the testator was in a state of perpetual we call it perpetual insanity, which is the state of being totally disconnected from reality. So if you've managed to demonstrate to the court on a preponderance of probabilities, so more likely than not, that the individual during that period of time was in a perpetual state of being disconnected from reality, then we can understand, or we can assume, that they did not understand or appreciate the will. Once that's proven, the burden is shifted to the party that is supporting or trying to uphold the will itself. And that party then has to demonstrate that the testator had a moment of lucidity when they were able to understand what they were doing, able to comprehend the act itself, and signed. So how do you prove incapacity? Very often there are factual indicators, and I know that Helen is going to speak to that, so I will leave her the time to do that. But otherwise, we tend to rely on expert reports. These are retrospective expertise. You have a neurologist or a geriatrician or even a psychiatrist reviewing the deceased's medical records and their medical history, and rendering an opinion on the likelihood of their capacity at the time that they prepared the will. Very often there are two competing reports, and then it becomes just part of a very litigious file, and obviously once you have experts involved, a very expensive and costly file. So that's the Quebec perspective. Thank you.
Thank you, Yoni. Helen, Yoni mentioned that there's a presumption of capacity in Quebec as well as factual indicator of incapacity. Maybe can you speak to this or to any other point relevant to capacity in common law?
Yes, thank you. And thank you, Yoni, for doing a recitation of the law, actually, not just in Quebec, but also really at the common law for the rest of Canada. What you have said is largely 100% applicable to the case law in the common law provinces. And so I'm not going to repeat it. We have the same presumption of capacity. That is the starting point, the same burden of proof on the person who's trying to challenge it, and opinions on capacity in litigation obviously is quite prevalent and is very expensive. Now, I want to highlight a couple of things at the common law. In the common law, testamentary capacity, the ability to make a gift on death, is really a legal construct. So the courts have said, oh, that's a legal test. It's not just a medical test. It's not just a medical diagnosis. And obviously, evidence of medical capacity can influence whether or not a person has testamentary capacity. It's not determinative. So obviously, if the doctor's opinion and the condition of the person is that they're in a coma state, then obviously that's going to be determinative. But the most difficult cases that we run into and why people litigate is that capacity is not black and white. It's like, the newfangled light switches in my house where you can kind of turn up or turn down the volume. And so the issue is, at what stage does a person lose the capacity to understand what is necessary to make a valid will or a valid trust or any other instrument that gives a gift to somebody else? And the common law has developed a number of tests, but I think this one is generally accepted in most provinces, although it's a BC case I'm going to talk about. But the willmaker needs to, first of all, know the nature and extent of their property. So you can't give away what you don't know you have. But in litigation, what often is quite contentious is when you talk about the extent of property, that brings into bearing, like, what is the value of that property? So quite often somebody will say, my mother gave the house to my brother and me this because she's out of, the real estate market. She doesn't understand a house in Vancouver is $3 million, and I have the balance of her RIF, which is, 100,000, for example. So that is an issue with respect to how much does the person need to know about the value of his property or her property and how it relates to the rest of the assets in their estate. The second element is that the will maker needs to know what are described as the natural objects of their bounty. I don't understand, but common law judgments always have very flowery language. But natural objects of their bounty really means like, who are the members of his family? Who are the members of her community, her charities? Does ultimately the beneficiaries make sense? Like, if I'm going to make a will and I'm going to disinherit, or I'm going to leave everything to Marie-Ève, do I recognize that Yoni is my child, for example? Or have I forgotten that because of my lack of capacity? The third element is that obviously the will maker needs to understand what she's doing. She needs to understand that this is a will, that it's to give away her assets, and in essence, understand the relationship between the property that's given and the people who she is giving it to. And finally, which I think is kind of a catch-all, there's this requirement of what I would shorthand say, does the will make sense? The actual language is something like forming an orderly desire as to the disposition of his property. But really it's, does the will hold together to reflect a kind of final, sensible, although not one that one would necessarily agree with, but, to understand that what's in that document is something that they actually know and approved. So because of those elements, and because those elements are generally never addressed by a physician, unless you retain someone before the person is making or signing the will, and you ask the physician to address all of these elements, it becomes a test where the importance of the lawyer who's drafted and met with the client is very critical. And in circumstances where the will maker has made it with, let's say, a lawyer that has no background with the client, or in some of the common law provinces with a notary public, which is something different than in Quebec. But those are circumstances where quite often there is an attack, because the work that ought to have been done at the time of assessing capacity from a legal point of view against the legal test has not been done. So those are my comments to say that ultimately, just as Yoni has said, challenging based on capacity is quite a frequent type of legal action, because people perceive their parent, their child, their friend, not to be, they have the long history with the person, and often they think, oh, that person could not have meant what they did by reason of what the wills reads, or, how they've observed the person during that period of time.
Yes, and in addition to cases where the capacity of the testator is called into question, there's also cases where the validity of the will is contested on based on the concept of undue influence, which is also referred to as captation or captation in Quebec. And it is not unusual for a challenger to contest a will based on both grounds, capacity, incapacity, and also undue influence. So Yoni, could you please describe how in Quebec such challenges unfold?
Yeah, happily. Just before I do so, I wanted to circle back to something Helen said, which our topic today and our discussion today concerns challenges to the estate plan. Part of our job as litigators and legal advisors and planners, estate planners, is to help people avoid these challenges. And something that Helen said struck me as important to note, which is if you're preparing a will and there is some doubt about your capacity because you're older or you've been diagnosed with some debilitating ailment, it is very helpful and useful to obtain what we call a contemporaneous assessment. Have a doctor, have a neurologist, have a geriatrician, someone who can speak to your capacity at the time that you're preparing the will to avoid a challenge down the road. Similarly, for challenges to the formal validity of a will, at least in Quebec, our advice is always, if you have the time, see a notary, get it done. It's an authentic act, much harder to challenge that. So I just want all of our guests to bear in mind that, we're talking about the challenges today, but there are definitely ways to avoid finding your estate in litigation down the road. So, back to the question at hand, Marie-Ève, you mentioned that challenges for undue influence are frequently joined with challenges to capacity, and that's true. We very often see a claim stating the deceased did not have the capacity to prepare their will and to leave everything to so-and-so. But if the court finds that they did have that capacity, then the court should also find that they only did so because they were under the undue influence of so-and-so. So common cases that we see involve siblings where one of the siblings or some of the siblings are privileged over others, or you have someone who's disinherited without any real explanation as to why. Others are in an individual who leaves the majority of their estate or a very significant trust in favor of a second or third spouse and very little to the children, or the children have to wait a long period of time before they have access to any of the estate assets. Those are common fact patterns that we see. Undue influence is not an easy case to make. It's defined. It connotes fraudulent efforts by a legatee to convince a testator to make a bequest in their favor. In order to succeed in your case, you have to prove those two elements. The fraudulent efforts, which essentially means, you had to have used lies and deceit and manipulation to manipulate the testator to do something. And you also have to demonstrate that those lies and those misrepresentations and that deceit were instrumental in convincing the testator to make or modify their will in your favor. So that's important to note, because it's not illegal to try to convince someone or to influence a testator to include you in their will for all of the wonderful things that you have done for them over the course of their life and your relationship, or maybe you have some form of need. But it's when you exercise when you invoke this fraudulent conduct that it becomes undue influence. The proof, as I said, is very difficult to make of these cases, because very typically undue influence occurs behind closed doors. It's done in secret. People aren't typically open about the fraudulent efforts that they've undertaken in order to secure a benefit under a will. There's very rarely a smoking gun. There's rarely an email that says, "Dad, if you don't leave this to me, I'm going to do Y," or, so-and-so is a horrible person, you should write them out of your will. Very rarely it's the case. So that typically involves gathering as much evidence as possible. These are circumstantial evidence of undue influence that when in the aggregate are sufficiently reliable for the courts to arrive at a presumption or find a presumption of coercion. So it's never a direct finding. It's usually a presumption. As I said, that's hard to do. It's hard to win. It's an extremely fact-based type of trial and hearing, which also makes it very difficult to appeal if you do prevail, or even if you don't prevail. Very difficult to appeal because the appeal courts tend to defer to judges of first instance when it comes to matters of appreciating evidence, appreciating the credibility of witnesses. So if you take your shot, you're usually done after first instance. So how does one go about identifying undue influence? There are various indicators that the courts have developed here in Quebec, one of which is controlling the testator's contact with the outside world and with others. So if you manage their correspondence, you take their messages, you read and draft their emails, you make their appointments, if you have that kind of control over the individual, that is an indication of undue influence. Evidence of alienation of the testator. So you keep the person isolated. You prevent them from maintaining and keeping close contact with individuals that they had previously had good and meaningful relationships with. If you're very involved in the preparation of a will, again, in Quebec, we have this notarial will. So if you have made the appointment with the notary, if you're the one who gave the notary the instructions and the individual in question, the testator simply shows up, meets the notary once and signs, that's a good indication. And finally, if you're an individual who incites animosity between the testator and other relatives or other friends and family. So no one indicator alone will be enough for the court to be satisfied that there's undue influence, but taken as a whole, you might be able to make your case here in Quebec.
Yeah, exactly. It's really fact-based. It's a really fact-based concept. Helen, is the concept of undue influence different in the common law provinces? Is it easier to make the proof of undue influence? And how do the courts deal with these types of challenges?
Well, it's never easy to make out a claim of undue influence. That's one of the more, or maybe the most difficult grounds on which somebody could take to challenge a will, for all of the factors that Yoni discussed. And it is quite clear that the law says, influence, undue influence, the concept is not persuasion, it's not cajoling. It has to rise to the level of coercion, force, fraud, fear. It's really literally the psychological gun against the head. And so as that is very subtle, as Yoni explained, is very difficult to do. It has to be influence that overbears the will of the person, so that the person doesn't even understand the act of giving it and they don't really approve it if the pressure were off them. However, it is often the allegation that is made. Often a parent will say, it's my sibling who's been doing that, and they've been, starting that since, my first parent died, etc. But the proof of it is very difficult. Now, we have a concept in common law, which is called suspicious circumstances. Suspicious circumstances helps the person who is seeking to set aside the will based on undue influence. And that is that where there are some facts that exist that the courts say these are indicators of suspicions, then the burden effectively passes to or transfers to the person who receives the benefit, the alleged undue influencer, to prove that the gift was made with proper understanding, knowledge, and approval and free will. Now, what are suspicious circumstances? Quite often, our clients tell us, well, this is suspicious, that everything that, their sibling has done is suspicious, or the second spouse. But really, suspicious circumstances include things like where there is physical or mental deterioration of the person, so that they're more vulnerable. They don't have to rise to the level of lacking capacity, because obviously if they lack capacity, the will would set out on that side, on that basis. But the deterioration of the person, if the will was prepared in secret, so obviously if I went and had Yoni make a will that I had him sign and that I prepared, and I'm not a lawyer, and I kept it under my, I kept it undercover until Yoni died, then that is going to be suspicious against Yoni's family, who would be the natural objects of his bounty, going back to the earlier test on capacity. The courts also look at what they call unnatural dispositions. So if Yoni had 5 wills, he left everything to his spouse and his children, and all of a sudden he leaves something to his law partner across the country, well, that is out of, the ordinary, and that alone raises some issue about, did Yoni really intend that? Obviously, when I'm helping prepare the will for Yoni as a beneficiary, that's a suspicious circumstance. If Yoni were not capable of controlling his personal affairs, if he were maybe not entirely incapacitated, but let's say he had given me his power of attorney and I was doing everything for him financially, and his knowledge of his assets and his finances were like no longer as astute as it used to be, that's a suspicious circumstance. Obviously, drastic changes in the personal affairs of him or his testamentary plan from before is a factor. And finally, the courts also look at the psychological or financial dependency of the beneficiaries on the willmaker, and also the personal, emotional, physical dependency that the willmaker may have on the person who is the beneficiary. So if a will leaves everything to a caregiver, well, that's suspicious. If the caregiver is a child and isolates the parent and doesn't let the parent have contact with the rest of their family, that is suspicious. Finally, I do want to mention an interesting case, because obviously, as Yoni said, everything is so factually specific. So you never can determine what an outcome of a case would be, because precedents are not useful in this area other than the legal test, which no one takes a dispute with. But in British Columbia this year, there was an interesting case where living parents sued their child for having unduly influenced them to give their house to him. Now, these actions are generally brought after the death. Oh, the sibling says, brother, you influenced our parents. Or second spouse, you influenced our mother or our father. But in this case, the parents who were still living and who were not incapable argued that they had transferred title because they were unduly influenced by their son. Now, the court applied the factors that I talked about and was looking at whether or not the parents gave the house of their own free, full, informed thought and will, and looked at whether or not the parents really had an opportunity for real independent legal advice. I mean, the transfer was made with a lawyer. Was there an ability for the parents to resist the influence of the child? And they found that, notwithstanding that the parents went to a lawyer, had the house transferred, the courts set that transaction aside. So that's very interesting, because I started off my comments with, it's very, very hard to do, but there's always exceptions, obviously, to any case. So I think that's what I can say about undue influence. It's popular, but difficult to make out in terms of a ground for challenge in the common law provinces. Maria.
Thank you, Helen. It was really interesting, that case. And also, I found it really interesting when you talked about unnatural disposition that can be found to be suspicious. So maybe, Yoni, if you want to talk about the bus cases that we had in Quebec that kind of was connected to unnatural disposition.
Sorry, just trouble unmuting myself. Apologize for that. Yeah, I also noted that very interesting, Helen, that you raised that. It was reminiscent of a case that we were involved in where the judge, although he didn't raise this principle of suspicious circumstances, and we challenged it in appeal on that basis, and the Court of Appeal did not get into that notion. But I think now that, Helen, you've presented it, we might take a new shot at that with the next file. The court found that it was very strange that the testator would not have left anything to his daughter. Why would he not leave anything to his daughter, and why would he leave everything to his spouse, who we represented? And he said it's very suspicious in the absence of any fight or other reason. I'm going to conclude that there was undue influence. It couldn't have been for any reason other than the undue influence of the spouse. Now, I think it begs the question, and you referred to that, Helen, you shift the burden of proof to overcome the suspicious circumstances. What the court didn't buy, and we didn't represent first instance, we only came in an appeal. We told the Court of Appeal, look, the judge in first instance completely overlooked all of the reasons to leave everything to the spouse. The spouse had devoted 25 years of her life to being with, caring for, promoting, supporting, doing all, was totally worthy of the entire estate. And there's nothing unusual about leaving your entire estate to your spouse. When you do so, usually you expect that spouse will then leave it to your children should they die afterwards. But that question didn't come up. So I think, Maria, that's what you had in mind when you asked the question. Helen, we will speak afterwards because it's something I will invoke in the next time it comes up in Quebec.
Yes, exactly. Thank you, Yoni, for talking about this case that we had. Helen, I just want to quickly discuss with you this concept of wills variation that you have in BC and what our guests need to know about that. And I understand that it's a concept that is specific to BC.
Well, actually, Maria, I think all of the provinces have what we call dependence relief legislation. So a will maker needs to provide for somebody who has been financially dependent on them at the time of death. And that type of legislation exists. But in British Columbia, we've gone far beyond that concept of dependence. And in British Columbia, any spouse that is common law or married, and any child, minor, adult, super rich adult child, can bring a claim for a variation of a valid will. So there's nothing invalid about the will. It meets all of the formal validity. It is made of free will. It's not subject to, undue influence or capacity. But the court has the ability to vary in favor of the applicant. And BC has created a huge amount of case law on this right, all the way up to the Supreme Court of Canada. And our session is too short for me to go into that other than to say the fact that we have wills variation legislation, which I do not call dependence relief in British Columbia, makes estate litigation very prevalent, and it makes estate planning difficult and creates a lot of issues for the administrator, executor, trustee of an estate under a will. And it's probably another topic that one day we can do another webinar series on, but it's just useful for people in BC to be aware that there is this anomaly.
Exactly. Maybe next year we can pitch this idea. I know from my personal experience as a litigator that disputes over the validity of the will extend over several years, resulting in substantial costs. Yoni, could you please tell us who has to assume the cost of litigation under the Quebec law?
You hear me now? Okay. Sorry about that. Again, I have trouble. I apologize. Yes, very, very good question, and one of the most relevant questions to clients. What is it going to cost them? And when do they have to pay? Do they pay immediately, or do they front the fees, etc.? So to understand the concept of costs, who assumes them and when, you have to understand to some extent in Quebec who has standing to make a claim. So in Quebec, it's first and foremost the liquidator who's going to be involved in almost every single one of these challenges. A liquidator has the obligation in Quebec to probate the will. So they go before the court. In Quebec, the probate is to confirm the formal validity of the will. So the liquidator has to do that. The liquidator also has to defend the will against the two other challenges. Insofar as a liquidator by law in Quebec also has to be represented by an attorney, the rules are that the liquidator has their legal fees paid for and paid for by the estate. So I'll jump to the punchline. It's the estate ultimately is going to cover all of these fees. The question is, who's going to do it throughout the process? So the liquidator gets to dip into the piggy bank and pay for their fees. It makes representing liquidators easier than it is to represent other individuals who are making a claim or a challenge who have to self-fund. So you have individuals who expect or believe that they have an entitlement to a portion of the estate. They haven't received it yet. They want to challenge the existing will or nullify it and revive the will that benefits them. But they have to put up all of the money in order to have this dispute. Now, it's true that the liquidator, on the other hand, is going to be defending and trying to uphold the will. But if it's a third party, the dispute is going to involve the various interested parties. So sometimes you have estates where the liquidator does not have an interest in the outcome. They nevertheless have a legal obligation to appear. So if you're a self-funded litigant, you're feeling the pain up front, and you hope to get to recover some of your fees on the back end. And the way to do that, first of all, is to prevail. And second of all, is to convince the court that the action that you took is actually in the interest and for the benefit of the estate at large. If you can satisfy the court of that, you're going to have your fees reimbursed. If you're the liquidator and you've acted in good faith, and you haven't acted abusively, you do not have to reimburse the fees that were paid in order to support the position that you took in court. So as I said, ultimately, the estate is what's depleted, whether directly from the estate or from the individual who personally has to put up the money, only to be reimbursed later. Marie-Ève.
Yes, it is indeed an important financial burden for a person who has to put it up front. Helen, could you please tell us more about how the costs of litigation are to be assumed in the common law provinces?
Yes, Mary-Eve. Traditionally or historically, I would say, people often thought that if you challenged the will because it wasn't valid for formal validity or undue influence or testamentary capacity, that the cost would come out of the estate. But the courts have moved away from that in all of the common law provinces. So sometimes costs can come out of the estate where the courts determined that the dispute arose out of the fault of the willmaker, the actions of the willmaker. So sometimes if you're asking for an interpretation of a clause in a will, the courts will say, well, maybe the clause gives something to Yoni, but maybe to Marie-Eve, it is appropriate or not inappropriate for Yoni and Marie-Eve to both go and pitch their position to the court about what that provision means, and nobody created that problem other than the willmaker. However, in the types of litigation that Yoni and I have discussed a little bit more fully today, when you have claims of incapacity and undue influence, it's generally a disappointed beneficiary or intestate heir who's trying to challenge so that they receive a benefit. And the courts have decided that those kind of challenges are often more characterized as traditional adversarial litigation between two parties. Somebody's trying to get a benefit, and it's not really against the estate or the will per se, but it is for their own personal interests. And in the common law jurisdictions, adversarial litigation costs are awarded based on success. So generally the rule is winner wins costs and loser pays costs. But in the area of estate litigation now, because it is still discretionary, the courts now take into account a whole bunch of factors in deciding the situation and in the exercise of discretion. So they look at, well, was it the willmaker who created the litigation? Was the challenge made by the plaintiff reasonable? Was the conduct of the parties reasonable during the action? Maybe it was reasonable to claim undue influence at the outset, but after, some evidence, after the examination for discovery process, it's no longer reasonable to carry it on. Was there an allegation of undue influence? And I stop here to say undue influence, as I said, is tantamount to a fraud claim. And so therefore, if I sue Yoni for fraud, just some other type of fraud, and I don't succeed, Yoni can get special damages, increased costs against me, because it is a very terrible allegation to make, and can affect Yoni's, professional standing, personal standing. So if there's an undue influence claim, quite often the courts consider that to be, personal litigation. And the courts will also look at different periods of time in the litigation and whether some portions of it should be borne by the estate and other portions not. And the courts will also look at the reasonable conduct of the parties in the litigation. Were there offers to settle? Were any of those offers reasonable? Were they taken, accepted, or not? So at the end of the day, costs are, for anybody who is intending to embark on litigation, they should not, as Yoni said, presume that they are going to receive their costs regardless of the outcome. And that is a very big, caveat to put on and to assess whether or not a matter should be brought. I should finally say, on the wills variation in British Columbia, the courts see that as adversarial litigation, so that costs are, even though the will is being varied, costs are awarded on the traditional scale of costs in the cause almost invariably now.
Well, thank you very much, Helen and Yoni, for your insight today. So I see that we are almost running out of time, but maybe we can address one question that we received from our guests. So we have a question that is, can a judge add words or even sentences to a will? So maybe Yoni, I don't know if you want to start with this question, or Helen?
Sure. The answer is quite simple in Quebec, and the notion of will variation is anathema in Quebec. So is adding or modifying a will. What a court will do is read the will, consider whether or not it is clear. If there is some ambiguity, it may interpret the will, but it cannot add language or modify the terms. So that's a straightforward, basic answer in Quebec.
And is it possible, Helen, in common law provinces to do so for a judge?
Yes, that's the shortest answer.
That's interesting that you can do that, because in Quebec, the judge does not have the power to do so. So you really have, it's the will as it is, maybe a bit interpreted, but it's the will as it is, or no will.
Technically, they don't add words as much as say these words have this meaning, I think is the better answer to it. But effectively, they can rectify. So if there was an intended word not, and the word not is not there, then the court can probate a will with the insertion of that word.
Well, thank you all for joining us today, and thank you to my fellow colleagues as well for this great discussion. And thanks to everyone who took the time to submit some questions. Unfortunately, we only had the time to address one, but if you want, you can contact Helen or Yoni directly to discuss these topics in more details. A quick reminder to please fill in the survey if you didn't already done so. The second webinar in the estate litigation series will be coming up on November 30th. So keep an eye out for the invitation, which will be sent to you by email. If you would like to review any of the past estate litigation webinars from the previous years, please visit the Fasken Institute website, Fasken Institute section on the Fasken website, which is fasken.com. And have a great afternoon or rest of your morning. And we look forward to seeing you at the next webinar.